You know, you look at those voting district maps sometimes, and honestly, they can look like some kind of abstract art, right? All these wild squiggles and shapes.
It really can.
But have you ever really stopped to think about how those lines get drawn? And, more importantly, the huge impact they actually have on our elections.
It's a fascinating and really crucial question.
Well, that's exactly what we're diving into today. One of our listeners sent in some really interesting sources on voting rights and, specifically, redistricting.
Right.
And it led us straight to a really pivotal Supreme Court case, Shaw v. Reno from 1993.
That's right. Shaw v. Reno is, well, it's a landmark case. Think of this deep dive as our way of exploring how the court really tried to define the role race can play, or maybe, more accurately, can't play, when states redraw their electoral maps.
Okay.
But we're not just looking at Shaw in isolation. The goal here is to trace the threads, find the similar legal thinking, the factual echoes between Shaw and other key voting rights cases that came later.
So, like, how the court's approach evolved or stayed consistent.
Exactly. We want to see if there's a consistent pattern in how the Supreme Court handles these really complex, thorny issues of representation and equality.
Okay, so to really get Shaw v. Reno, we need some context first. This whole issue didn't just pop up in 1993, did it?
Oh, absolutely not. We need to rewind a bit. Think about the post-Civil War era. You have the 13th, 14th, and 15th Amendments. Huge promises, right? Ending slavery, citizenship, voting rights for Black men.
Yeah, foundational stuff.
Foundational, yes, but the reality, especially in the South, was very different. Almost immediately, state governments started rolling out all sorts of discriminatory practices to block the Black vote.
Things like poll taxes, literacy tests.
Exactly. Black codes, poll taxes, literacy tests, a whole toolbox designed specifically to disenfranchise African Americans, despite the constitutional guarantees.
And that's really the backdrop for the Voting Rights Act in 1965, isn't it? It was a direct response to all that suppression.
Precisely. The Voting Rights Act, or VRA, was a landmark piece of legislation aimed squarely at stopping these discriminatory voting rules that had persisted for nearly a century.
And it wasn't just about banning bad rules, right? There was that pre-clearance part.
That's key. Section 5, pre-clearance. It meant that certain states and counties, places with a documented history of voting discrimination, had to get approval from the federal government, usually the Department of Justice, before they could change any voting law or procedure.
So they couldn't just swap one discriminatory practice for another?
That was the idea.
Yeah.
And crucially for our discussion today, the courts made it clear that this pre-clearance requirement also applied to redistricting, drawing those legislative district lines, which states have to do after every census.
Okay, that makes sense. Now, fast forward a bit. You mentioned another case, Thornburg v. Gingles from 1986. How does that fit in before Shaw?
Jingles is super important here. It laid the groundwork for what are called majority-minority districts. The Supreme Court essentially said, look, under the Voting Rights Act, sometimes you might have to draw a district where a racial minority group forms the majority.
But only under certain conditions.
Yes, very specific conditions, and these are crucial. First, voting in the area has to be racially polarized, meaning white voters and minority voters consistently prefer different candidates.
Okay.
Second, the minority group has to be large enough and, importantly, geographically compact enough that you could actually draw a reasonably shaped district where they'd be the majority.
And if those conditions are met?
Then the VRA might require creating that district to give the minority group a fair shot at electing their preferred candidate. The idea was to counteract situations where minority votes were consistently diluted or canceled out.
Got it. That provides really critical background. So now we can zoom in on Shaw v. Reno. What actually happened in North Carolina?
Okay, North Carolina, early 1990s. And get the statistic. Between the end of the Civil War in 1993, so over 125 years, the state had only sent 7 African Americans to Congress, total.
Wow.
And in 1990, even though Black residents made up about 20% of the state's population, none of North Carolina's 11 members of Congress were Black.
Okay, so a clear lack of representation there.
Definitely. Then, after the 1990 census, North Carolina got a 12th seat in Congress. So the state legislature set out specifically to create a district where African American voters would be the majority. Their stated goal was to increase Black representation.
And North Carolina was one of those states needing pre-clearance, right, under the VRA.
It was. So they had to send their plan to the Department of Justice. And interestingly, the DOJ, under Attorney General Janet Reno at the time, actually rejected their first plan.
Why?
They said the first plan only created one majority Black district, and they felt the state could and perhaps should draw 2.
Ah, so the pressure was actually to create more minority opportunity districts?
That was the implication from the DOJ's objection, yes. So the North Carolina legislature went back to the drawing board. And this is where District 12 comes in. And its shape was, well,
Unconventional. You used that word earlier. Sounds like an understatement.
it really was. This new majority black district, the 12th, stretched for about 160 miles, mostly following Interstate 85.
Like right along the highway?
Pretty much. In some places, it was literally no wider than the I-85 corridor. It snaked through the state, cutting across counties, towns, other districts, basically linking pockets of African-American population that were geographically quite separate.
So it wasn't based on, say, existing county lines or natural communities.
Not really. Its shape seemed almost entirely driven by the goal of connecting dispersed minority populations to create that majority.
Yeah.
It looked, frankly, bizarre on a map.
Like you said before, almost like drawing lines just based on race, ignoring everything else.
That was certainly the argument that came later. But despite this very strange shape, the DOJ did not object to this second plan. And in the 1992 election, an African-American candidate, Melvin Watt, did win the seat for the 12th district.
But that wasn't the end of the story.
Not at all. A group of white voters, led by Ruth Shaw, filed a lawsuit. They argued that this district, the 12th, was so extremely irregular, so clearly drawn based on race, that it violated their rights under the 14th Amendment's Equal Protection Clause.
Their argument was that it was racial discrimination against them, even though the goal was to help a minority group.
Their claim was that creating districts primarily on the basis of race, regardless of the intent, is itself a form of racial classification that violates the Equal Protection Clause. They saw it as a racial gerrymander. The lower district court actually threw out their case initially.
But the Supreme Court saw something worth looking at. What was the core constitutional question for them in Shaw v. Reno?
The big question was, does a claim that a state drew district lines predominantly based on race, creating a really bizarre shape for seemingly no other reason, state a valid cause of action under the Equal Protection Clause? Basically, can you sue over racial gerrymandering even if it's intended to help minorities?
And what did the court decide?
It was a close one, 5-4. But the majority, led by Justice O'Connor, sided with Shaw. They said, yes, this kind of claim is valid under the Equal Protection Clause, and they sent the case back down to the lower court.
Okay, so let's unpack that majority opinion. What was Justice O'Connor's reasoning?
Well, she started by acknowledging the ugly history of racial gerrymandering used to harm minorities. But then she made this really important comparison
To what?
to another famous case, Gamillion v. Lightfoot from 1960.
Ah, the Tuskegee case,
Oh,
right?
yeah.
Where they redrew the city limits into that crazy 28-sided shape just to exclude black voters.
Exactly. O'Connor pointed to Gamillion where the court said, look, if a district's shape is so bizarre that it can only be explained as an effort to fence out voters based on race, courts can step in under the 15th Amendment.
So she was saying District 12 looks suspiciously like that, even though the intent here was supposedly remedial.
That was the parallel she drew. She argued that District 12's shape was similarly extremely irregular and hard to explain on grounds other than race. The majority felt that classifying citizens primarily by race, even for what might seem like good reasons, is inherently suspect.
Why suspect?
Because it conflicts with the core principle of equality. They worried that drawing lines like this essentially amounted to racial segregation, grouping people solely based on skin color who might live miles apart and share little else.
It reinforces the idea that race is the most important thing about a voter.
That was the concern. That it promotes the idea that people should be judged, politically grouped, based on their race. And they also worried it could lead elected officials to think they only represent the racial group that forms the majority in their district, not everyone.
Like it could deepen divisions rather than heal them.
Yes, O'Connor explicitly warned about the risk of balkanizing us into competing racial factions. The fear was that this kind of race-based districting moves us away from a system where race doesn't matter.
So what was the actual legal standard they set?
They established that if a redistricting plan is so bizarre on its face that it can't be understood as anything other than an attempt to separate voters by race, then it demands the highest level of judicial scrutiny, what's called strict scrutiny.
Meaning the state would have a very high bar to justify it.
Exactly. The state would have to prove the district was narrowly tailored to achieve a compelling government interest. And just saying, we wanted to elect a black representative wasn't automatically enough. The case went back down for that analysis.
Now, you mentioned it was 5-4. What did the dissenters say?
The dissenters made some strong points, too. Some argued that considering race is sometimes necessary in redistricting, especially given the history of discrimination, and it shouldn't be unconstitutional unless it actually denies a group the equal opportunity to participate.
Like focusing on the outcome, not just the process.
Sort of. Others pointed out that people of the same race often do share political interests because of shared experiences, so grouping them isn't necessarily illegitimate. And some felt race-conscious districting should only be suspect if it aims to hurt minorities or entrench the majority, which wasn't the goal here.
So what happened when the case went back down? Did North Carolina manage to justify District 12?
Well, initially, the district court actually upheld the plan again. They decided that complying with the Voting Rights Act was a compelling interest that justified the district.
But it didn't end there.
Nope. Back up to the Supreme Court it went in a follow-up case called Shaw v. Hunt in 1996. And this time, the Supreme Court struck down the district for good.
What did they say then?
They essentially doubled down on the Shaw v. Reno reasoning. They concluded that District 12's shape was predominantly based on race, and that the state's justification complying with the VRA, as interpreted by the DOJ, wasn't compelling enough to survive strict scrutiny in this specific extreme instance. The shape was just too much.
So the enduring legacy of Shaw v. Reno is this principle. Race can't be the main thing, the predominant factor, driving the drawing of district lines. If it looks like it is, courts will look very closely, and it's likely unconstitutional.
That's the big takeaway. It set a major precedent, not just for voting districts, but potentially for other areas where race might be considered, like school assignments or housing policies. Race cannot be the overriding predominant factor without triggering serious constitutional questions under the Equal Protection Clause.
Okay, so that's Shaw. Now, let's try to connect it, like you said earlier. How does this thinking resonate in later cases? You mentioned Bradovich v. Democratic National Committee from just a few years ago, 2021. That wasn't about district shapes, was it?
No, Bradovich was different on the surface. It involved challenges to two specific Arizona voting laws under Section 2 of the Voting Rights Act and the 15th Amendment. One law required throwing out ballots cast in the wrong precinct, the out-of-precinct policy. The other restricted who could collect and return absentee ballots for another person, often called ballot collection, or sometimes pejoratively, ballot harvesting.
Right, different set of facts.
Yeah.
So where's the connection to Shaw?
The connection lies in the underlying concern about state election laws or practices potentially discriminating against minority voters and hindering their equal opportunity to participate. Even though Bradovich wasn't about the shape of districts, it was about whether these procedures had a discriminatory effect.
Okay, how so?
Well, the argument from the Democratic National Committee was that both Arizona laws disproportionately affected minority voters. The out-of-precinct policy, for example, resulted in statistically more discarded ballots from Hispanic, Black, and Native American voters, often due to things like frequent precinct changes or polling place confusion.
And the ballot collection law.
The argument there was that restricting ballot collection disproportionately burdened minority voters who might have less access to reliable mail service or transportation, and who sometimes relied on community organizers or activists to help return their ballots. So the claim was these laws, while maybe looking neutral, had a disparate impact.
Disparate impact, meaning a neutral rule hits one group harder than others.
Exactly. So while Shaw dealt with an explicit, though perhaps well-intentioned, use of race in drawing lines, Bradovich dealt with rules that were facially neutral but allegedly had racially discriminatory results in practice, making it harder for minorities to vote effectively.
So both cases involved the court scrutinizing state actions related to elections for potential harm to minority voters' ability to participate equally.
Precisely. Even though the legal framework was different, equal protection in Shaw, VRA Section 2 in Bradovich, the core concern is similar. Ensuring state election systems don't unfairly disadvantage minority voters. Now, it's important to note the court upheld the Arizona laws in Bradovich, but in doing so, it still analyzed the impact of those laws on minority voters. The court laid out new factors for evaluating Section 2 claims, arguably making them harder to win. But the process of examining the laws for discriminatory effect echoes the kind of scrutiny, albeit under a different standard, applied in Shaw, where the court was concerned about state action disadvantaging voters based on group identity.
Okay, that makes sense. The focus is on equal participation, whether the threat comes from district lines or voting rules. Now, what about Gill v. Whitford from 2018? That was about partisan gerrymandering, right? Republicans drawing lines to hurt Democrats in Wisconsin. How does that link to Shaw, which was about race?
Yeah, Gill is interesting because the group characteristic was different political party, not race. The claim was that the Republican legislature in Wisconsin had cracked and packed Democratic voters so effectively that the statewide map was unfairly biased towards Republicans, violating Democrats' rights.
Cracked and packed, meaning spreading Democratic voters thinly across many districts so they can't win, or concentrating them densely in a few districts so their votes are wasted elsewhere.
Exactly those techniques. So the connection to Shaw isn't about race directly, but about the fundamental principle of whether it's constitutional to draw district lines specifically to disadvantage a particular group of voters and entrench the power of another group.
So Shaw said you can't use race as the predominant factor to sort voters. Gill asked, can you use party affiliation as the predominant factor to achieve an unfair advantage? Is that the link?
That's a great way to put it. It's about the manipulation of district lines based on group identity to skew representation. In Shaw, the identity was race. In Gill, it was party. The plaintiffs in Gill argued this partisan gerrymander violated their equal protection rights, just like in Shaw, and also their First Amendment rights of association. They felt their votes counted less than Republican votes simply because of how the lines were drawn.
Was the court sympathetic to that argument?
Well, the Gill case ultimately didn't resolve the core question of whether extreme partisan gerrymandering is unconstitutional. The Supreme Court sent it back down on a technical issue called standing.
Standing. Meaning whether the specific people suing had actually suffered the right kind of harm to bring the lawsuit?
Exactly. The court said the plaintiffs hadn't proven they suffered individual harm in their specific districts, as opposed to a general harm to Democrats statewide, so they didn't rule on the merits. However, the issue itself, the fairness of drawing lines based on group characteristics to achieve a desired political outcome, is clearly related to the concerns in Shaw. Both cases grapple with how far states can go in sorting voters into districts based on group identity, be it racial or political.
It's about the fundamental fairness of the map, regardless of which group is allegedly being targeted by the line drawing.
Right. Both Shaw and the arguments in Gill raise profound questions about what constitutes fair and equal representation when district lines can be drawn in ways that seem to predetermine outcomes based on who lives where and how they're grouped.
Okay, so pulling this all together then. Shaw v. Reno was really pivotal. It established that race can't be the overwhelming reason for a district's shape, subjecting such districts to strict scrutiny under the Equal Protection Clause.
Absolutely. Even if the goal seemed remedial, the court flagged the dangers of classifying voters primarily by race.
And we see echoes of that concern for equal participation and the potential harms of group-based line drawing or rulemaking in other cases, like Bronovich, which looked at the disparate impact of voting rules on racial minorities.
Right, examining potentially discriminatory effects even of facially neutral laws.
And Gill v. Whitford, which, although focused on party, raised similar fundamental questions about manipulating districts to disadvantage a specific group of voters.
Exactly. All three cases, in different ways, push us to think about what fairness and equality really require in our election systems. The Shaw principle that voters shouldn't be reduced to just their race for districting purposes kind of underpins the scrutiny in the other cases, even when the specific legal test or group identity differs. They're all wrestling with how to ensure representation isn't unfairly skewed by the lines on the map or the rules of the game.
This has been incredibly helpful in understanding how these complex legal ideas connect. It really shows that drawing lines on a map is far from simple.
It really isn't. And it leaves us and you, our listener, with a really important question to ponder, doesn't it?
Which is?
Considering these cases, what does fair representation actually look like today in a country that's incredibly diverse, but also, let's face it, pretty politically polarized?
Yeah.
How do you draw lines or set rules that ensure everyone gets an equal shot, especially groups who face historical discrimination, without falling into that trap the Shaw Court warned about balkanizing ourselves or making race or party the only thing that matters?
It's a massive balancing act, trying to remedy past wrongs without creating new kinds of divisions or inequalities.
It truly is, finding that balance between addressing historical injustice and striving for, a colorblind or politically neutral ideal in how we design districts and run elections. That's the ongoing challenge, something to definitely think about next time you see one of those squiggly district maps.